Hi everyone. Welcome. Welcome to the live stream. It's Monday morning and we're hitting the ground running on this morning. Welcome. You'll notice this backdrop is a little different. I moved into my house. Let me get in the center here so that it actually looks nice. I moved into my house and I unpacked my stuff, and so now I have things. And I can make this look a little bit more like an office and less like I'm sitting in a jail cell somewhere with just a black background. So welcome. Hope everyone can hear me. I hope everyone had good weekends. I hope everyone is having a, pleasant enough Monday morning. Welcome. So let's just dive into it, all right? We've already talked about SB8 once, so check out my last video for that information for more of a deep dive. But however, that was just talking about the, Supreme Court deciding not to bar the SB8 from going into effect. But now we have a lawsuit from the federal government basically trying to get the law declared unconstitutional. So this is like a whole new development, and we got to dive right in. I got my Dolly mug. It's Monday morning. Let's get into it. All right. If you're new here, my name's Leija. I'm a real-life lawyer on a mission to demystify the law and how it affects your everyday life. That being said, however, I am a lawyer, but I'm not your lawyer. Nothing that I say should be construed as legal advice, and you should always seek the advice of a licensed attorney before making any legal decisions. Okay? Let's jump right in. I will note that super stickers and super chats are activated. That goes towards literally keeping the lights on in here. So thank you so much for your generosity. If you're interested in donating to people who need money to get abortions in Texas, or frankly to get out of Texas to get an abortion, I have linked some orgs down below. There are many to choose from. Take your pick. Send your money there if you'd prefer. Great. I want to jump into this because I respect your time and I want to just get into it. So hold your questions to the end. Your super chats, super stickers can come, but just know that I'm going to just, jump into this and power through. So, I'll check out your questions at the end. Let's get into this. So, in a nutshell, in case you need a refresher on SB8, it bans abortions after 6 weeks-ish. So whenever a fetal heartbeat can be detected, which is around 6 weeks. It has been pointed out that it's not really technically a heartbeat because an embryo doesn't have a heart at that point, but there's like an electrical current enough that a machine can pick it up. And those are called fetal heartbeat bills because that's kind of where they draw the line. Anyway, the way that they're enforcing the ban, however, is giving private individuals the right to sue anyone performing an abortion or aiding and abetting the performance of an abortion. So private individuals sue in civil court under this law, and they can then get at least $10,000 for every claim that they win. So it's pretty wild. This is not a typical, this is not how these laws are usually written. And it was, pretty obvious that the Texas legislature passed this because they knew that past fetal heartbeat bills have been deemed to be unconstitutional. So instead of saying, maybe we should stick with like the Constitution, they've decided to try to thwart it by throwing in these procedural hurdles that make it hard to figure out who to sue. Because again, if you are trying to sue to preempt a law, to say like this law should not be enforced at all, you usually sue like the attorney general of the state to keep it from being enforced. However, this law specifically says the attorney general does not enforce this law, or the district attorney or whomever. And so it's just private citizens. So you can't really sue one individual, like one state representative, to bar it from being enforced. And how do you sue every individual in Texas? Difficult. However, the DOJ has tried to do just that. Moira, my beautiful English bulldog, has joined us in the room. So if you hear snores, just know it's just her. just probably taking a little nap. She just had her breakfast. Or maybe she'll get into something and break a few things. Who knows? Chew on a shoe? It's live, baby. We have to go with the flow. All right. There's a few questions that came up that I didn't touch on in my last video that I wanted to note. Okay. So under the law, this law specifically, someone who perpetrated an RAPE, an assault, that led to the pregnancy that is then aborted, that assaulter cannot sue for that abortion specifically. Theoretically, however, this would, I assume, require that the impregnated person prove that they were raped, which is notoriously difficult, especially in Texas. So that seems like a dubious protection at best. Also, the impregnated person, the person seeking the abortion, is not the target of this law. In fact, the person seeking the abortion cannot be sued under this law. That's not the point of the law. The law is specifically targeted at the doctors and people performing the abortions and the people, trying to help a person seek an abortion. That's why this is so dubious, because it's like, it could be so many people, and it means that these abortion providers are going to get sued over and over and over again and have to pay at least $10,000 for every time they're sued if the case is won, and so it could put them out of business. So a lot of them don't even want to try to tango with this law at all, so they've just stopped providing abortions. And by a lot of them, I mean, I think all of them. So, yeah, it's meant to kneecap abortion providers, not sue the people seeking abortions. Then there's this issue of standing. So if you're not familiar, standing is what we call the right for someone to sue someone else in court. You have to have standing in order to sue someone, meaning you have to have a cognizable injury or some imminent cognizable injury that is being caused in order to sue. This is because we don't want people to just be like, well, I'm mad about this thing, so I'm going to just sue about it, even though it has nothing to do with me and doesn't affect me in any way. I'm just personally offended by it or something. We don't want that to be possible. We want people who are in court, clogging up the court system, to actually have a cognizable injury. That is in the Constitution. Article 3. Person has to have actually suffered or will imminently suffer a cognizable injury. So theoretically, if a private citizen were to bring a lawsuit under this law, which hasn't happened yet, it's a new law, there's just the looming threat of it that is keeping people from getting abortions in Texas now. If a private citizen were to bring a lawsuit in federal court, they wouldn't have standing, and the court would dismiss their claim, theoretically. Because again, we're dealing with the federal Constitution when we're talking about standing. However, SB8 is a state law that will likely be brought in state court. So it would fall under the purview of the Texas Constitution. Now, believe it or not, I am not a Texan constitutional law scholar, but I have read the words of people who are. And apparently standing under the Texas Constitution is sufficiently vague enough that abortion providers are probably not going to want to just rest assured that any lawsuit brought against them will be dismissed based on standing. It's not an open and shut case. Like, judges could interpret it broadly enough that they'd allow the case to move forward, standing issues and all. Or they would find that a private citizen suing under the law has standing. Okay, so at this juncture, abortion is effectively banned in Texas, despite the fact that it is quite literally against the Constitution, because Roe v. Wade has not been overturned. It hasn't been overturned. The Supreme Court decided not to bar the law from going into effect on a procedural issue. Again, check out my last video for background on that, but it has not overturned Roe v. Wade. Is there a looming threat that they might overturn Roe v. Wade? Yes. This upcoming session, they do have a case coming before it on a Mississippi abortion law that could give them the opportunity to effectively rule that Roe v. Wade is overturned. All right, so after this private challenge of the law failed at the Supreme Court level, again on procedural grounds, the federal government has stepped in because it does have an interest, a cognizable interest, standing in protecting the constitutional rights of the people who live in Texas, because they are also U.S. citizens. And since Texas is infringing on those clearly established constitutional rights, Texas is the one being sued. All right. Let me see. Let me go to the next one here's the cover page of the complaint. It was filed a few days ago. United States of America is the plaintiff versus the state of Texas. The U.S. does this type of lawsuit, sues entire states through the Department of Justice, the DOJ, and more specifically through the Attorney General, who currently is Merrick Garland, who, if you'll recall, was supposed to be Obama's nominee to the Supreme Court at the end of his term in office. But then the Republicans made the Senate sit on the confirmation hearing, and then Trump got to swoop in and nominate Neil Gorsuch instead. And I'm still mad at it, but I digress. All right, this is not an unprecedented move by any means, the DOJ suing a state. The U.S. has sued states before, especially when it comes to constitutional and civil rights violations by the states, of which there have been many. For example, the U.S. sued Texas in 2013 over its voter ID laws, claiming that the law has the effect of restricting voting rights based on race. And this eventually led Texas to change the law ever so slightly, just enough to remedy the constitutional issues raised by the DOJ. And they continue to require IDs to vote in Texas, just slightly less unconstitutional. All right. So let's look at the complaint. I've linked it in full below, but I've kind of picked out a few key highlights, as it were, that I wanted to show you here. So, like I said, the United States has the authority and responsibility to ensure that Texas cannot evade its obligations under the Constitution and deprive individuals of their constitutional rights by adopting a statutory scheme designed specifically to evade traditional mechanisms of federal judicial review. The federal government therefore brings a suit directly against the state of Texas to obtain a declaration that SB8 is invalid, to enjoin its enforcement, and to protect the rights that Texas has violated. So they're seeking an injunction, which again means that they're asking the court to tell Texas it can't enforce this law. And they're asking the court to then declare the law unconstitutional. They also say that this affects the federal government because it tries to control everyone, including federal agencies, and bar them from performing, funding, or supporting abortion services. This is a claim that basically allows them to add a few more constitutional violations to the list that they're asking the court to rule on. All right, let's see. So here's what they're asking the court for. The United States therefore seeks a declaratory judgment that SB8 is invalid under the Supremacy Clause and the 14th Amendment, is preempted by federal law, and violates the doctrine of intergovernmental immunity. So let's just break that down a little bit. So they're seeking to have the court declare that the law is unconstitutional under the Supremacy Clause, which says that federal laws trump state laws where they directly overlap, which is the case here. The 14th Amendment, which Roe versus Wade found to include the right to have an abortion as long as it's before viability, which is around 22 to 24 weeks. It's preempted by federal law, again, meaning there's a federal law that directly contradicts this law. And it violates the doctrine of intergovernmental immunity. The doctrine of intergovernmental immunity basically prevents the state governments from intruding on the federal government's sovereignty, and vice versa. Basically, they allow individuals, or in this law, because it allows individuals to be sued for aiding and abetting abortions, this complaint says that that would affect federal employees, like at federal prisons, for example, who are required by federal law to assist people in their custody and care with obtaining abortion counseling and transportation. Or there's like the Job Corps, which is funded by the Department of Labor. It would also increase costs for people trying to leave Texas to obtain abortions. In the complaint, they list a whole swath of government programs operating in Texas that would be affected by the law. And they're basically trying to bolster their argument that this law directly affects the federal government. So they have a valid claim that the state is trying to regulate the federal government, which goes against the intergovernmental immunity doctrine. And they have a valid interest in it being declared unconstitutional. All right, so that's what they're asking for. Pretty straightforward. However, I will note that they do have to overcome one hurdle, which is I think they did pretty well in this complaint, but it is novel, according to people. This is kind of a new argument that they're having to make. And that is that the Constitution, there's this issue that the Constitution prevents against state actions and violations of people's rights, but private actors are not similarly bound. That's why a private business, for example, can make you wear a mask and refuse you service if you don't, even if there's not a state mandate about it. See, for example, oh, that was a gross sound. Did you just hear that sound that Moira made? Ew. See, for example, the really amazing videos that are coming out right now of people being like forcibly removed from flights for not wearing masks. They can do that because they're private companies. They're not bound by constitutional protections. Similarly, this is why Twitter can kick Trump off and not be subject to the First Amendment issues. It's a little muddier than that, but that's the basic premise. I think Moira's trying to eat my candles. So, all right. Basically, the problem is that the law technically tells private individuals that they can sue to enforce it. So how do you argue that private individuals are violating the Constitution? So they do a pretty good job, I think, of making this argument. They basically say Texas has gone to unprecedented lengths to cloak its attack on constitutionally protected rights behind a nominally private cause of action, and it nonetheless has compelled its judicial branch to serve an enforcer's role. State action, as that phrase is understood for the purposes of the 14th Amendment, refers to exertions of state power in all forms. Under the state action doctrine, private actors also may be found to function as agents or arms of the state itself, and thus are bound by the Constitution. All right. The Supreme Court has deemed individuals to be state actors where they exercise powers traditionally exclusively reserved to the state. SB8 vests individuals with law enforcement authority, a power traditionally reserved exclusively to a sovereign, in a manner that appears to be unprecedented, based on Chief Justice Roberts' dissent in that very recent Supreme Court decision not to bar SB8 from being enforced. All right. So when private actors are performing duties that would normally be reserved to the state, they can be considered state actors and held to the requirements of the Constitution, is what they're arguing here. I find the argument pretty convincing. This is not like, this argument itself is not new. It's not new to argue that individuals acting in the same way that the state would be acting are bound by the Constitution. Some of the earliest examples of this happening was with the towns that were formed around big big operations. So you had these towns that were like, people would live there and then they'd go to the factory and they'd work at the factory and they'd come back. And then the factory would issue money that could only be spent in the factory town. That there was a case on that ruled that the town, the factory, in creating this town and governing people like this, was acting like the state and therefore had to abide by the Constitution, was no longer just a private actor. So they're extending this argument that giving individuals this right and then allowing the judiciary to enforce it via awarding this money means that the individuals are acting like the state and therefore can be enjoined as a whole from enforcing this law because it's against the Constitution. All right. So the fact that the rights are constitutionally protected by Roe v. Wade, which again has not been overturned, it can't stand. Even if it's private individuals enforcing it, they're acting as like the state. So it's a novel argument to apply to an abortion case, but they've created a novel law in an attempt to completely thwart constitutional protection. So you need some novel legal arguments to kind of overcome that. All right, so the complaint also claims that the law affects interstate commerce because people seeking abortions would have to cross state lines to obtain the abortions, but also because it prohibits aiding people with obtaining abortions, including through monetary donations, which uses interstate commerce to be sent and received. And this kind of bolsters their argument that the federal government has an interest in getting involved because the federal government has unique power to govern interstate commerce, basically anything that crosses state lines and may have ties to economic activity of some sort. This is important not only for this case, but also because recently Nancy Pelosi has vowed to bring abortion rights to the federal level and try to pass a federal law protecting people's rights to an abortion. As with all of Ms. Pelosi's promises, I will believe it when I see it, but this is what she claims. And in order to be able to pass this kind of law, the federal government has to have the authority to do so. The feds can't pass laws about just any old thing. They have limited jurisdiction, meaning that there are limited topics on which they are allowed to pass laws, and the rest is all within the state's jurisdiction. But their jurisdiction does extend to interstate commerce, which is a tool that they've used a lot to pass laws that don't necessarily seem related to interstate commerce. Like abortion doesn't seem immediately to be related to interstate commerce, but it can be argued that you have to cross state lines if it's banned in one state to get it in a different state. This law is affecting people's ability to send money related to abortions. Therefore, money passes state lines when it is wired or sent or transferred via Venmo or however else. Therefore, they could argue potentially that this has to do with interstate commerce, and therefore they can pass laws about it. So the fact that they're arguing this in this case is cool, because if the judge agrees with them, then any sort of federal law that gets passed related to abortion, they will have court precedent agreeing that this has to do with interstate commerce to kind of help bolster the law and any arguments that would come out, because Lord knows that if the feds try to pass a law to allow abortion access on a federal level, there will be lawsuits brought to try to challenge that, probably based on like a states' rights argument. And then another point I wanted to raise, we talked last time about the undue burden test. This is a requirement that any restrictions on abortion do not create an undue burden on the person seeking an abortion. However, it has been found to not be an undue burden to require a 24-hour waiting period, to force the person to hear the fetal heartbeat, to force the person to tell the other parent of the embryo about the abortion, to force minors to go in front of a judge for approval before getting an abortion. Like, those have been found to not be undue burdens. So courts have a pretty lenient view when it comes to this, based on, how a lot of people would think would create an undue burden, but fetal heartbeat bills have been found to be unconstitutional and to create an undue burden more than once. So SB8 tries to get around this by saying that the person getting sued can use as a defense that there is an undue burden as to their ability to access an abortion. Meaning, like, if they get sued under the law, they can then say, like, well, this person that's seeking the abortion, there's an undue burden to their access. I'm not really sure how that would even play out. But this lawsuit that the DOJ brought, the complaint claims that this defense related to undue burden is not good enough. Because when constitutional rights are at stake, it's not something you can, like, throw into a law as a defense. Like, if the law says you can discriminate based on race and housing, but if the person being discriminated against can prove that it's a discrimination, then they win. That doesn't make sense. That's not how we deal with constitutional rights. So those are the most interesting points I found in the lawsuit. Again, they're asking that the law be found invalid under any one of the theories that I mentioned above, that it violates the Supremacy Clause, that it violates the 14th Amendment, that it's preempted by federal law, or that it violates the doctrine of intergovernmental immunity. And they're asking the court to permanently enjoin anyone, including private individuals who are acting like the state, according to them, asking the court to say that they're enjoined completely from enforcing the law. So the case was brought by the DOJ. It was filed. The first listed attorney is a guy named Brian Boynton, who is the acting head of the civil division of the DOJ. So just as like a background, we have Merrick Garland, who's the Attorney General, and as the Attorney General, he's the head of the DOJ. And then the DOJ has a criminal division and a civil division. The criminal division, they're the ones that are the prosecutors at the federal level that prosecute would-be criminals. So they sue people for criminal statutes, drugs violations, money laundering, things like that. That's all on the criminal side. And the civil side has to do with non-criminal matters. In this case, this is not a criminal matter. This is a civil rights issue, a constitutionality issue. This is a civil matter. So it falls under the civil side of things. And Brian Boynton, I just like saying that last name, Brian Boynton is the top of the civil division in the DOJ. Anyway, so that's basically where we're at. This was just filed a few days ago, so the state of Texas has yet to respond. There was some drama the other day because the suit, so basically once a lawsuit is filed, it gets assigned to a judge within the jurisdiction where it was filed. This lawsuit, I believe, it was filed in Texas. Let me see, it was filed in the Western District of Texas in Austin. And so originally it was assigned to a judge called Judge Yeakel, who was a Bush appointee. Though that judge did invalidate past attempts by Texas to limit abortion access, all right? But then it was reassigned to a Judge Pittman because Judge Pittman heard the last case against SB8, the one that went up to the Supreme Court and died there. So they wanted to assign it to Judge Pittman to make sure that it was all kind of more cohesive because they've already, I think Judge Pittman's a guy, I don't actually know. He already heard the case, that last case, so he has like some expertise in it at this point, so it made sense to kind of keep them all under one umbrella. And I think the DOJ actually argued in favor of it being assigned to Judge Pittman because he heard the last SB8 challenge, but also he's an Obama appointee, and he granted the motion to dismiss, or no, I'm sorry, he denied the motion to dismiss in the original SB8 challenge, meaning that he allowed the lawsuit against SB8 to move forward. So I assume the DOJ wanted to be assigned to him so that it would hopefully be beneficial to their side. Like hopefully he would be a bit more sympathetic to the DOJ's side. So now we just wait. We wait for Texas to respond. I feel like they might really push back on this, even though I thought the arguments were great. And I think where Texas will have the strongest pushback is on the very thing that they built into the law to begin with, the argument that the individual private citizens are the ones enforcing it, so there's no state action here, so it can't be considered unconstitutional, which we all know is bullshit. Like, it was written because they wanted to get around the state action thing, but like they still want to control abortion access, and they're doing so via state action by passing the law and then having the judiciary enforce it. So we'll see how far they get on that argument, but it's an area where they'll have at least like a little bit of footing to stand on, kind of like arguing against that. Because like, again, fetal heartbeat bills, unconstitutional. We've already decided that. Unless, again, the Supreme Court has a case coming before it this coming term about abortion, and if in that they decide that Roe v. Wade is overturned, then that upsets all of this. And there are a number of states that have provisions, laws that state if Roe v. Wade is overturned, then this law goes into effect, basically banning abortion. So they're just kind of like sleeping, these laws, waiting dormant until Roe v. Wade gets overturned, and then they immediately go into effect. I don't even know how many states that's in, but there's a lot. There's a lot of them. So should Roe v. Wade be clearly overturned in the upcoming term, a lot of this is going to go out the window. However, it's possible that in this Mississippi law case that they're going to be hearing in this coming term at the Supreme Court, that they'll rule really narrowly on it. They won't overturn Roe v. Wade. They'll just make a narrow, probably another carve out of the protections of Roe v. Wade, but not a complete doing away with it. That's also an option. So I'm not trying to be a sensationalist here. It could very well happen that they make a decision that doesn't actually affect large swaths of the United States. So time will tell. Time will tell, my friends. Anyway, meanwhile, Greg Abbott, the governor of Texas, is out here suing school districts for mandating mask wearing in schools because, you know, freedom to choose what you do with your body is very important to him. And he's signing laws that aim to limit social media companies' ability to censor people. You know, people like Daddy Trump mustn't anger father, you know. So he's doing a lot. We're doing a lot. Well, I'll keep abreast of this issue, these issues, all of them, and try to share any updates over on my Twitter and Instagram or wherever I see stuff. And that's that. Now we wait. That's the background. Let's get into questions and comments. Again, super likes and stickers should be going. So feel free. Any money donated goes towards literally keeping these lights on. Or there's links down below that will allow you to donate directly to orgs that are helping people obtain abortions in Texas. Feel free to go that way as well. Let me know if you have any questions. I'm just going to start scrolling through these comments. and see what y'all have to say. Thank you so much for joining me today. I hope this was helpful in your understanding. Yeah. Okay. So the Hipaa thing. Someone asked about Hipaa. I don't know. You know, because there's this whole issue with like the doctors. If there is a medical emergency, there is an exception in the law for medical emergencies. However, they would have to prove it. The doctor would need to note it on the record, saying like there was a medical emergency here. I believe, now that I'm thinking about it, it would probably be, okay, someone is sued under this law. And so as a defense to this lawsuit, say you aided and abetted an abortion. Say you're the doctor that performed the abortion. You're getting sued under this law. And you know that it was a medical emergency. And so you want to use that as a defense, saying like, no, I didn't violate the law. It was a medical emergency. I'd imagine you can get permission from the person who got the abortion to share that medical record. And I imagine the person who got the abortion would want to allow that to help the person that gave them the abortion to not get sued and to be able to defend themselves in court. So since it's a defense, I feel like there's a lot of reason why a patient would consent to it being shared. You know what I mean? But I'm not really sure, because again, this is a new law. This hasn't actually, no one's sued under the law yet. This hasn't been enforced. We're just arguing about the fact that it's not constitutional and shouldn't be enforceable now, trying to preempt any future lawsuits. All right. Happy Monday to everyone. Sorry, I'm just reading these comments, so I'll pop them up. Hi, Catherine. Thank you. Happy Monday. Okay, Shakespeare, I see you. I love it. The backdrop, right? These old books are gifts from my mother. I found this statue at an antique store this weekend. I don't know who that is. They have an Adam's apple, but they also have a ponytail and a crown. So there's like an androgynous vibe there that I can get behind. Let's see. All right. Let's see what questions we have. Yeah, I mean, who knows? What about people who work insurance? They could just sit down and write all the people that they see who got abortions. Well, there's one issue there, and that is that paying for abortions via insurance is specifically listed in the law as like aiding and abetting. So if you work at the insurance company and you've paid for it, then you would be self-incriminating if you were to make a list of all the abortions that you've helped fund. Let's see. We got some other questions here. Hello. Thank you, Henry, for the super chat. Since it's a civil action, could multiple people sue the provider over the same procedure? No. Well, no. I mean, probably not. So the provider cannot be sued more than once for a single procedure. There's a provision of the law that says like basically a double jeopardy provision. You can, as a defense, say, well, I've already been sued and paid $10,000 because of that specific procedure. And I believe then, so it's not like you would be paying $10,000 for the same procedure over and over again, but you could pay at least $10,000 for every procedure that you get sued for, if that makes sense. Let's see. Okay, this is a good one. What if a Texas citizen goes somewhere else to get the abortion? Does this law apply to them if they go somewhere where there is no law? It does not. This only applies to abortions that are performed in Texas. However, there is the question about like if you aided and abetted from a different state, but the abortion was still obtained in Texas, or you sent money to Texas for someone to obtain an abortion, that would likely be in violation of the law. Again, the law has not been enforced yet, so the parameters of it are gray at this point, but I believe that if you were to send money into Texas, technically you're breaking the law. I didn't mean to click on that, but okay. How does it make any sense for people to sue someone else as a private affair? I only stand it making sense that the clinic with a policy sues a doctor. I know. It doesn't make sense. That's why this is such a new law. It's like, it's not been done before. So they're just trying to thwart any sort of constitutional enforcement to it, like blatantly so, which is pretty shocking. So you could sue Blue Cross Blue Shield. It appears as such. Yes, if you can prove that they helped pay for an abortion, they would be aiding and abetting. Let's see. All right. Any other questions? Let's see. We have one that's not really related, but I'll answer it. Not exactly on topic right now, but how's the house renovations going? The electricity is pretty much done. I have lights. I had to update all of my electrical in my old 140-year-old Victorian house, in case you missed that. I have a whole video walking through it that you can check out on my channel. It all had old knob and tube wiring, which if you're not familiar is the very first type of electricity that could ever be installed in a house. And it's just like raw wires, live wires floating in your walls. Terrifying. So I had to get it all ripped out and redone. So I moved in all of my stuff this past week, and I am settling in. The unpacking is going very slowly. If you want more like behind the scenes information about how that's going, pictures, whatever, I'm sharing more of it on my Instagram, and you can also join me over on my Patreon. Link is in the description below, where I share more of my personal life and inside behind the scenes stuff. So find out more there. Okay. Well, oops. Oh my gosh. These chats are popping up faster than I can click on them. Yeah, I mean, wouldn't having to prove standing limit the ability for a private citizen to sue a clinic for the 50 or so abortions they could have done during any given week? I went over this a little bit at the beginning, but or earlier in this stream, but yeah, standing is a huge issue here. And under the Constitution of the United States, the federal Constitution, I think it would be pretty easy for a federal judge to dismiss any case brought by a private citizen for standing, because the law is pretty clear on that you have to have a cognizable injury, and it just does not apply for private citizens. However, this is a Texas state law, so it would likely be brought in state court in Texas. Therefore, it's a little bit more murky, because apparently the Texas Constitution, when it comes to standing, is a little bit more murky. And so a judge, and a reminder that there are a lot of conservative judges on the bench there, a judge could very easily decide to interpret standing broadly enough that this counts. I'm sure they could argue something like the society is injured every time there's an abortion, so any individual who lives here is injured, you know? Ooh, this is interesting. I don't know anything about this. Thank you for the super chat, Genevieve. Thoughts on the Satanic Temple's move to protect abortion under religious freedom? I had heard about that. I haven't looked into it. I mean, I feel like everything's fair game at this point, right? If we're doing novel law writing to try to thwart the Constitution, we got to do novel lawsuits to try to enforce our constitutional rights. So I'm all about it. I want to look into that. Maybe I'll read that, and maybe I'll share some of my thoughts over on, like, I tend to share my thoughts on things over on Twitter or Instagram, because I don't want to bombard people on here in like my community posts on YouTube with random stuff. So yeah, wild, a good idea, a fun time. Let's see. So is someone actually breaking the law by getting an abortion, or is it just the harm that people sue for? Because if it's illegal, doesn't that contradict the idea that it's private? does contradict the idea that it's private, which was, again, constitutionally found to be protected in Roe v. Wade. However, no, by getting an abortion, this law doesn't affect people obtaining abortions. It affects people giving abortions or aiding and abetting the procedure, not the people actually getting the abortion. So technically, you're not breaking the law by getting the abortion. You're breaking the law by providing the abortion. And that is strategic because they're trying to kneecap abortion providers. Let's see. Thank you, everyone, for joining. I hope that this has been helpful. If you have any other questions, now's your time, but I'm going to try to wrap this up a little bit. Okay, this is funny. So abortions at international airports in Texas would be okay. Interesting place for a clinic. That is interesting. I don't know airport jurisdiction. Is that a federal jurisdiction? Because that's a big argument that they're making in this lawsuit, is that this law is also trying to regulate federal employees and agencies working in Texas, which is against the Constitution. So, I mean, technically it applies to every abortion in Texas. And so they're arguing, yes, this applies to every abortion in Texas, including the ones that are aided by or funded by federal employees, which is against the Constitution. So if an international airport is technically federal, then it would probably also fall under that argument. All right. Hello. I'm sorry that you missed the whole stream. I am wrapping up. Thank you so much for everyone who joined, for all the super chats and super stickers. Your generosity is awesome. Don't forget to donate to the links down below or any other org that is helping people in Texas. I will, again, keep my eye on this issue as it unfolds. I'll share updates over on Twitter or my Instagram. Join me there. Thanks so much for watching. Have a good day. Goodbye.